Hey everyone, welcome. So today we're going to go over chapters 32, so bankruptcy, uh, along with chapter 50 and 51. So we're going to do bankruptcy law, insurance law, and then we are also going to do landlord tenant law. So let's begin. Okay, I'm going to start sharing my screen. We're going to get rocking and rolling right here. All right. Okay, perfect. So let's begin with bankruptcy. Okay, so here we go. So let's take a look at the start of it. So we have a debtor. So that's someone that owes money to another entity. So let's say, for example, I own a construction business and I took out a $1.2 million SBA loan from TD Bank. I'm the debtor in that scenario because I'm the one that owes money to the bank. And then we also have creditors, which we went over yesterday. It's entities to which a debtor owes money. So let's say I owe money to TD Bank for my company for a loan that they gave me. I own TD Bank money. They're the creditor. And then we also have an insolvent debtor. So let's say, for example, a good example would be Lehman Brothers. So they had in 2008, they had billions and billions of dollars of debt. What happened was Lehman Brothers went bankrupt, if you probably know, because of the 2008 market crash, and they became insolvent. So they could not pay their debts in a timely fashion because they didn't have the capital to do so. So therefore, they would be an insolvent debtor. And then because okay, and then because of this, in 2005, Congress established a BAPCPA. So this is basically a revision to the current U.S. bankruptcy code. So there are different types of bankruptcy that they have. So we have Chapter 7 bankruptcy, Chapter 9 bankruptcy, Chapter 11 bankruptcy, Chapter 12 bankruptcy, Chapter 13 bankruptcy, and Chapter 15 bankruptcy. So Chapter 7 is a sale of the debtor's assets by the trustee and distribution of money to creditors. So let's say we declare bankruptcy because we're delinquent on our mortgage. And let's say we also have a car loan. If we file for Chapter 7 bankruptcy, the trustee can sell our house and they can sell the car in order to pay off the remaining debts. So that would be Chapter 7. Chapter 9 would be an adjustment of the municipality's debts. Chapter 11 would be a reorganization of our financial affairs. Chapter 12 would be for family farmers. Chapter 13 would be for individuals, and then Chapter 15 would be a recognition of insolvency. So let's keep looking. Okay. So let's take a look at the steps of a bankruptcy proceeding. So number one, all bankruptcy cases are going to begin with a filing of petition for bankruptcy. So people are going to file for bankruptcy. So after they do file for bankruptcy, the court's going to grant an automatic stay for creditor actions against the debtor's estate. An automatic stay, which we'll go over, is further down here. It basically tells the creditor, hey, you cannot bring upon any more litigation against the debtor. So usually when someone declares bankruptcy, there's going to be a judgment or lien opened up against them for a breach of contract. For example, on a home mortgage, let's say they can't afford their debts anymore, and the bank is suing the debtor for breach of contract for a home mortgage. So if they file for bankruptcy, um, the the code, the bankruptcy code can provide for an automatic stay. So that will end. So that shows that they cannot bring or continue legal action against the debtor or against their property if they file for bankruptcy. Okay. So then after that, the court's going to determine whether an order of relief should be granted. An order of relief is going to come up soon. The creditors meet with the debtor. So that's a creditors meeting. There's a payment plan that's created and approved. So let's say that they do debt settlement or something like that. That's very common with debt settlement lawyers, mainly for personal debts. So if people break up personal loans for medical bills or they have an insane amount of credit card debt, a lot of people will go to debt settlement in order to get a reduced or more reasonable monthly payment. The payment plan is carried out through actions of the trustee of the debtor. And then after that, if there are any debts remaining that are not included in the plan, they're going to be discharged and charged off. Okay. 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 So we have liquidation. So this is what happens in Chapter 7 bankruptcy. So people will liquidate their assets, meaning that they're going to basically sell off their assets in order to pay off their debts. So they sell their home, they'll sell their car, whatever they can sell, they're going to sell them to the trustee, who's going to take over administration of their estate. So that'll typically be an attorney. So they're going to sell whatever they got in order to make sure their debts are paid off. So when someone files for bankruptcy, they're going to file a voluntary petition. So that's their initial filing. So the debtor has to state or understand that that there are other types of bankruptcy available, and they're choosing liquidation. So between chapter 12 or chapter 7 or whatever it might be, they know willingly that they're choosing chapter 7. So when they do this, their pre-petition assets, which is the assets they had before they filed for bankruptcy, form bankruptcy estate. So assets that are gained after filing the petition are not part of the bankruptcy estate. So let's say after we filed for bankruptcy, we bought a new couch. That's not going to be considered an asset under our initial petition that we filed. So that would be an example right there of how the bankruptcy estate works. So in order to file bankruptcy, you don't have to prove you're insolvent. In order to file bankruptcy, though, you must prove that you owe some type of money to a creditor or another party. So you also need to submit extensive information regarding your financial affairs as well. So if you're filing bankruptcy to avoid paying a debt on a mortgage, that could be a problem, because let's say you have the funds to do so, you might not be able to get approved for the petition. Okay. Then we also have an automatic stay. So all this means is that the creditors cannot bring any further litigation against the debtor if if an automatic stay is approved. So let's say, for example, we get a judgment before a bankruptcy filing, and let's say we file bankruptcy. That judgment that we received from a lender to pay up for the mortgage on our home can no longer be brought up upon. So now we also have an order of relief. So it means that a bankruptcy relief is ordered and the bankruptcy proceedings can continue. So let's say, for example, we file bankruptcy because we're 120 days delinquent on our mortgage note. We have to prove in order to get an order of relief that we can't pay debts as they become due, and the custodian took possession of all the debtor's property within 120 days before filing the petition. Okay. So then we all after that happens, if we get an order of relief, they'll have a creditors meeting. So it will be a meeting of all the creditors listed in the chapter 7 and everything that's required for the liquidation. So the bankruptcy judge is not going to go there, but the debtor will be there, their lawyer will be there, and all the creditors that they owe money to will be there. So that will give them a plan as well. And if the debtor does not show up, the courts may refuse to grant them bankruptcy. So then we also have preferential payments. So there are certain creditors that might get preferential payments compared to some other creditors. So let's say, for example, trying to think of a good example. I want you guys to come up with it. Read the this paragraph here. I want you guys to type in the chat what would be a good example of preferential payments in a bankruptcy case. I'll give you guys some time. Guys, I'm gonna say it one more time. Here it is. Okay, so basically, let's say, for example, okay, okay, here's the question one more time. Okay, so an example of a preferential payment, let's say you owe three people money. Let's say you owe a construction company 3,000, you owe the bank 1,500, and you owe a credit union 1,000. So let's say you have $5,000 within your account and you pay $3,500 to the construction company. That would be a preferential payment because you pay them, and then let's say you file bankruptcy for the other debts. So they would be a preferential payment. So we can recover a preferential payment if they're not fair to the creditors. So a trustee can void a fraudulent transfer of property. So let's say, for example, we wanted to transfer property that's going to be made with intent to defraud creditors. So let's say, for example, we want to transfer assets. Let's say we have a trust fund that we want to hide by declaring bankruptcy from creditors. That would not be allowed because it's a fraudulent transfer of property. Then we also have a discharge. So that's a federal court letter signed by a bankruptcy judge stating that the debtor is immune from creditor actions to collect debts. So let's say, for example, our business is going through a personal bankruptcy and we get a discharge letter. So it'll tell the creditors, hey, these debts are discharged. You guys no longer have a legal right to collect. So that would be a discharge. And we also have a reformation agreement. So that's an agreement in which a debtor can pay a debt even though it could be discharged. So that's an exception. So let's say, for example, I get a loan from my friend who owns a company. Let's say he owns a boat business, and my business that supplies him with the repairs for the boats files for bankruptcy. Let's say he lent me $400,000. We could, because of our relationship, we can enter into a reformation agreement for me to pay the debt, even though it might be discharged. So let's say the court said, "Hey, all the debts, all the creditors, the debt that Jared owed to them is discharged." But if we make a reformation agreement, I could still agree to pay that debt. So, in order for this to occur, the reformation agreement must be made before the debt's discharged. The debtor has to be able to cancel the agreement. The agreement should contain a statement notifying the creditor that the law does not require the agreement, and the agreement has to be filed within a bankruptcy court. So, these are the four steps. And the reformation agreement is just if a debt's discharged, they still have to pay. That's all it is. You see here with all these companies that filed bankruptcy. So I mentioned Lehman Brothers, they filed bankruptcy $691 billion. WorldCom 103 billion, General Motors 82 billion. So I just want to go through the key terms. Okay. I want to do a little review here of some of the terms. Can someone tell me what a insolvent debtor is? Can someone tell me real quick?
It's a debtor who can't pay debts in a timely fashion.
Good. Okay, I'm gonna do one more. Can someone give me an example of a order of relief? If you want me to go over one more time, I can.
Yeah, can you go over it one more time, please?
Sure thing. So it's basically when a bankruptcy relief is ordered, the proceedings can continue. So let's say we filed a petition, right? If we look at the steps in a bankruptcy case, the petition goes down. We file the petition. Let's say we get approved for the petition. Then the court's going to grant an automatic stay, which means that the creditors can no longer sue for assets in our estate. And also, we can determine after that if we should get an order of relief. So if we get an order of relief, all that means is that, hey, this is good. We can do the automatic stay and that we can do a creditors meeting to settle on the debt. So that would be an example. And then I'll do the last one. What is the role of a trustee? What do they do?
I think okay, I don't know for sure, but isn't the trustee the lawyer of the creditors, and he collects like all the liquidated debt or something like that? Oh yeah, wrong.
Scroll up. So trustee, they're going to take over the debtor's estate. So they're going to be responsible for selling the non-exempt assets and distributing the proceeds of the sale to the creditor. So it's some of the non-exempt assets are houses, cars that need to be paid off. If there's existing debts and liens against the vehicles or pieces of property, the trustee is basically a bankruptcy attorney who will be responsible for the sale of the assets. So that's the role of a trustee. Okay. All right, this one does have a lot of material in it. I would highly recommend you guys study it. I just want to go over the key terms. That's the main thing. So let me go down significantly. Oh, good. Perfect. Yeah, so this I'm gonna have to go down a lot because it's weird. It goes 32, 50, and 51. Environmental law. Okay, here we go. Finally. Let's go over 50, landlord tenant law. So we have the landlord, which is the person that owns the property. So if you guys, for example, if you rent an apartment, the landlord will typically be a company that owns the building. So let's say, for example, you rent in Royal Palm Place, right? So let's take a look, Royal Palm Place. So if you rent an apartment here, right, in this building, it's owned by a company called Investments Limited. So Investments Limited would be your landlord. I know that because I used to work there. So that would be an example right there. And then you also have the tenant or leasee. So let's say I rented an apartment in Royal Palm Place. I'm the tenant. So Royal Palm Place owns the building and I'm renting from them. So we're going to hold possession of the property, but we don't hold an ownership interest. That would be whatever company owns the building. So we have a leasehold estate. And then the agreement that we have for the lease, meaning terms, any type of clauses we have in there, and then the actual rent payment itself would be the lease. Okay. And then we have a definite term lease. So these are leases that are going to automatically expire at the end of a term. So for example, if we sign a lease on a warehouse for 3 years, specifically for us to pay rent for the next 3 years, it's a definite term lease. So we also have a periodic tenancy lease. So this is also known as a month-to-month lease. To live so short term, you could enter into a periodic tenancy lease if it's available to you. That way, if you decide, hey, I want to pack up and leave, or I have to go, you could go ahead and break the lease if it's month to month. So the difference between definite term, periodic tenancy: definite term means you have to stay there. Periodic tenancy means you can leave at any time during the month. And we also have a tenancy at will lease, so that means we may terminate it at any time. So, and then the last type of lease that we have is a tenancy at sufferance lease. So if a tenant fails to leave the property after getting a notice of eviction and the lease was terminated, the landlord can either permit the tenant to remain or to demand repossession. So we can do either or. Okay. And we also have a covenant of quiet enjoyment. So that means all it is a right for the tenant to quietly enjoy the land. So basically, all that means is that the landlord cannot interfere with the tenant's use and enjoyment of the property. So even though, let's say, the landlord owns the apartment building, they can't go and basically say, hey, we're renovating your unit because we own it, whether you like it or not. We can't do that because of the covenant of quiet enjoyment. Or let's say we have a rental house, for example, and we want to paint it, but we have someone in there for a lease. We can't go in there and basically say, hey, we own it. We're gonna repaint the house, whether you like it or not. We can't do that because of the covenant of quiet enjoyment. And then we also have an actual eviction. So when you're physically prevented from entering the lease premises, that's going to be an actual eviction. So let's say, for example, you have a fob for your apartment and your fob stops working for your room. That would be an actual eviction. Now, if you're physically prevented from entering any parts of the premises, so let's say you're completely banned from getting into the building itself, that's a full eviction. But if you're prevented from entering a part of the premises, it's a partial eviction. So, for example, if you are renting an office building and some of the offices are locked, that would be a partial eviction. So if a full eviction would be you're completely blocked from even entering the building to begin with. So partial, you're blocked from some of the rooms. Full, you're blocked from the entire real property. Or let's say, for example, your landlord, they fix a pipe and let's say the pipe explodes and it's so bad that you can't use the apartment anymore, or the apartment was completely destroyed. Let's say something happened in the building. That's a constructive eviction. So let's say that our heater broke and it's like 98 degrees. Let's say we're in the middle of the Florida heat and it's 98 degrees in the office and you have a team of 10 employees and you can't have them sweat. Let's say you request the landlord to fix the heater. We wouldn't be able, let's say he or she refuses to fix it. That would be a constructive eviction. And then we also have an implied warranty of habitability. So all this means that the premises needs to be fit for residential purposes. So let's say, for example, we have a apartment building that people want to stay in. We need to have we need to basically have a requirement that the building can be used for residential purposes if that's what it's intended to be. So now we're going to go over waste. So let's say we do something to the property before we leave. Let's say we punch a hole in the wall, or we do something to the property that's not allowed under our lease agreement. That would be considered waste. So let's say we have a backyard. We were renting a house for a year, and we have a backyard and we cut down trees and the landlord didn't want it. That would be considered waste. So in most states, tenants can't make alterations that would affect the condition without the landlord's consent. So you see this a lot when people renovate their space. Before people do a renovation project on their space, or they want to do a build out, which some people will do, they have to get approval from the landlord first in order to renovate or change how the space looks. It's called alterations. So for example, if we had a pet grooming store and we wanted to turn it into a pizzeria, we would have to get approval from the landlord to be able to put the equipment in to make it a pizzeria. So that would be an alteration. We'd have to get the landlord's approval. So then we also have common areas. So that's an elevator, yard, lobby, elevator, stairs, just areas that are used by all tenants. So for example, if you guys ever lived in Parliament Hall at FAU, the common areas would be the gym there, the main lobby, the study rooms, etc. So those would be the common areas. Okay. So then we also have rent. I think you guys know what rent is. I don't have to go over that. And then we have a rent escalation clause. So let's say the businesses, let's say, for example, interest rates go up, or let's say property taxes increase, or let's say the tenant's commercial business's revenue is expanding where they can afford a higher rent expense. In the lease agreement, the landlord could put in a rent escalation clause saying, if property taxes increase by this much, we have a right to raise the rent. So they could put a rent escalation clause in the lease. So you guys know how I talked about liens and judgments. So if you are delinquent on your rent, let's say whatever the contract, 45 days delinquent on the rent, the landlord's going to put a lien on your property. So basically this means that you're going to have to initiate court proceedings in order to settle with the landlord, or else you're going to be evicted from the property. Okay. All right. And then we have assignment. Do you guys remember? I want you guys to remember, what is assignment again? We went over it in the previous chapter. I want to see if you guys know.
Isn't it handing over your rights to someone else?
Yep. So it's
In a
basically the
contract?
rights. Yep. So let's say, for example, we could transfer interest in a lease property to our friend. If we transfer our entire interest in the lease property to our friend, that's an assignment. Good job. So we also have a sublease. So let's say, for example, we lease an office space that's 5,000 square feet. But let's say we want to reduce our size and we have another company that wants to go in there and use some of our space. So let's say we say, hey, we'll take 2,500 because that's all we need. We're going to sublease you another 2,500 out of the 5,000 that we currently sign. So that means that's going to be a landlord-tenant relationship between us, the original tenant, and the subleasee. So if we decide to do that, we need to get the landlord's consent. But the person's not going to have any legal obligations to the landlord. So you basically become the tenant. They become the tenant to the lease. So if your subleasee does not pay rent, the landlord can hold you responsible for the rent payment. So essentially, you become almost like a mini landlord in a sublease. So we have certain different types of breach of condition. So we have forfeiture. So let's say, for example, we decide to not pay our rent. That would be considered under forfeiture. So we fail to perform a condition stating the lease. So let's say we fail to pay our $5,000 a month in rent. That would be a forfeiture. Next is destruction of the premises. So let's say there's a fire that destroys the lease or destroys the office suite that was supposed to be used. Let's say there's a fire in there. That would automatically terminate the lease. And there's also surrender. So let's say, for example, we speak with our landlord, say, hey, look, we are going to move to Washington. But let's say we have a lease in Wisconsin. Let's say I have 2 months left on my lease. Say, hey, look, I got to move to Wisconsin for a new job. Can we surrender the agreement? That way, that because I'm going to be moving. So that would be a surrender. And then we also have an abandonment. So let's say, for example, we move out of the lease premises before the end of the term, and we default on the rent payments. So if we move out, we're basically voluntarily evicting ourselves. We're basically saying, hey, we're making an offer of surrender. We can't afford it anymore. So the tenant behavior is going to call it abandonment. So the landlord will take the property and the tenant's going to be relieved of the rent obligation. Okay, so can you guys give me the difference between a definite term lease and a periodic tenancy lease?
I have a quick question actually about the abandonment.
Sure.
It's the move out before the end of the term. Are they also forfeiting to pay before the end of term?
So let's read it one more time. So if they default on their payments, so a default is basically an inability to pay your debt. Let's say that we can't, or we're rent so due, we go into default. So the tenant has to enter into default with the landlord, which means that they can no longer pay. And then once they do that, they can leave the premises, and that would be considered abandonment. So before that must happen, the tenant must default on the rent payment. In addition to that, they also have to have no intent to return to the property. So they can't come back a month later saying, hey, I was staying here. So those two things need to happen. That make more sense?
Yes, thank you.
Okay, perfect. All right. So can you guys tell me the difference between a definite term lease and a periodic tenancy lease?
I think someone put it in the chat.
Okay, let me look. Good. Perfect. Okay. Good. That's right. Can someone give me an example of a constructive eviction?
I guess like if our AC broke in the apartment and the landlord refused to fix it, we can't stay inside during the summer. It's like 100 degrees inside. So I guess that'd be a constructive eviction.
Perfect. Yep, that's right. And I'm going to do one more. What's the difference between an actual eviction and a partial eviction?
An actual eviction is the physical prevention of the building, whereas a full eviction is prevention of the entire property.
Good. Yeah, that's pretty much it. An actual eviction means that you're restricted from the entire property. So let's say a home, you're restricted from entering to the home. That would be an actual eviction. But let's say you have an apartment. Let's say you still can go inside the apartment in the lobby, but you can't access your unit. That would be a partial eviction. Good job, guys. I think you guys are good on this one. I think you guys feel really comfortable. I mean, it's pretty straightforward. So let's go to insurance law. There's a lot in here. So insurance is basically a contract. So an insured party is going to make payments to the insurer in exchange for an insurer's promise to make payment or transfer goods to an insured or named beneficiary in the event of injury or destruction of property. So do you guys, you can raise your hand or you can put a comment in. You guys all have car insurance, right? Yep. So you guys have car insurance on your car. So you pay a premium every month to the insurance company just in case if your car gets damaged. So let's say you get into an accident and the auto repair shop's charging you $7,000. Your insurance would cover a good portion of it. And then the remaining amount would be you would have to pay what's called a deductible. And then you pay a certain monthly payment to the insurance company just in case just to have the right to the insurance. So that's all insurance is. Next, we have an insured party. They make the payment called a premium, like I mentioned. So the insurer, so let's say, for example, who do you guys have car insurance right now with? Just so I can get an idea. I want to be able to put an example.
Progressive.
Hi, Geico.
What do you have, Geico?
Yeah.
Okay,
I
so
got
Geico,
Progressive.
yeah, Progressive, Geico. So right now, you guys have, let's say, for example, whoever said Geico, Geico is your insurer. So they're going to receive payments from the insured party, also the beneficiary for that insurance. So let's say, for example, you are the insured party, you pay Geico, and let's say you get into an accident. You are the beneficiary of that, so therefore you're going to be paid. So in this agreement, the contract that you do with the insurance company, how much they'll insure you for, the monthly payment, and the deductible, that's going to be called an insurance policy. So in most insurance policies, except for life insurance, which I'll get into, the beneficiary and the owner of the policy are the same person. So, for example, you have Geico car insurance or Progressive auto insurance. The person who owns the policy and the beneficiary is going to be the same person. And then next we have risk. So the potential for loss. So this basically means that whenever you sign an insurance policy with an insurance company, they take some type of risk. So they're going to risk some type of property or life to the insurance company. So let's say you make a payment to the insurance company. So if for whatever reason something happens, the insurance company takes the risk of a destruction of loss or property. So they're going to be the ones paying for the car crash or the ones paying for the home damage. So that would be an example of risk. So that's the potential of loss. Now, insurance companies will transfer and distribute their risk, and that's known as risk management. And then we also have moral hazards. So some people who believe that they're insulated from risk are going to behave differently. So let's say, for example, that they have a car and they have good insurance on it, they might drive more carelessly. Next, you have to have an insurable interest on property or life. So a person must be subject to economic loss if there is damage or harm to the property. So let's say, for example, you want to have insurance for your house. If your house burns down, that's going to cause you significant economic loss because let's say you put thousands of dollars into it. Let's say you have a mortgage on it that you pay $3,000 a month for. That would be an insurable interest in a property. Or that could also occur for a person too. So let's say, for example, Tesla, right? Elon is the face of Tesla. If Elon were to die tomorrow, Tesla's stock price would likely go down pretty significantly. So Tesla can insure Elon Musk's life because they're going to suffer an economic loss if he were to die. So the insurable interest is a life. So a company can do a life insurance policy for its CEO if they're instrumental in their success, like Bill Gates with Microsoft, Steve Jobs with Apple, or Elon Musk for Tesla. Okay, next we have an effective date. So as soon as you send in a policy, So let's say you get a policy, there's going to be an effective date. So let's say you sign an insurance policy with Allstate, and they say, hey, the effective date for this policy is going to be August 15th, 2024. But let's say that you get injured before August 15th, 2024, and that meets the criteria of the insurance. The insurance coverage will not come to you. So what will happen is the insurance agent will write a binder. So that's going to be an agreement that's going to give you temporary insurance until the company decides to accept or reject. So let's say, for example, you get injured on August 10th. The insurance, if there's an effective date 2 weeks later, you're not going to be covered by the insurance, even though you signed it. Okay. Next, we have an incontestability clause. So that means if, let's say, for example, we've been paying premium on time for 2 years, everything's been all good, we can't contest any statements made in the application. The reason why this is done is so that the insurer can't delay payment if it decides to investigate the application for fraud. So let's say the insurance company, Allstate, believes that you're trying to fraudulently have car insurance. Well, if you've been doing it for 2 years, because the incontestability clause, they can't prohibit the coverage for you. So let's say you get into an accident, they can't deny you coverage, even though they're investigating your application for fraud. And then we also have an anti-lapse clause. So that's going to be a grace period. So let's say, for example, we forget to pay the premium 1 month. A lot of insurance companies will do an anti-lapse clause. So they say, hey, you forgot. It's okay. We're going to give you 30 days to pay. Now, we also have an appraisal clause. So let's say, for example, you have a home that you're insured $300,000 for, but let's say you say it's worth $600,000. The insurance company can put an appraisal clause in the contract to appraise the property that is insured. And then we also have an arbitration clause. So if there's a dispute regarding the contract, the insurance policy, you guys can go to arbitration, which we already went over in previous chapters. Okay. Okay. And then we also have different types of insurance. So we have individual insurance. So that would typically be something on it, someone's life or their health insurance. So dental insurance, vision, car insurance would be individual insurance. And then we also have group insurance. So that would cover an individual's life. So let's say, for example, we had insurance that would insure a whole family. That would be group insurance. But let's say we had individual insurance on a car that only you own. So that would be individual insurance. And then the other one would be group. And let's say there's a business risk. So a lot of businesses, they will have what's called general liability insurance, which I'll go over in a minute. But that would be a commercial insurance. So this is basically that will cover some type of business risk. So let's say we get a lawsuit, someone sues us and they win. If we have general liability insurance, the insurance will pay them out. And then we also have property insurance. So if there's a fire that happens to our home or business property, theft, anything like that, there's property insurance. And then if something happens from accidental injury, there will be casualty insurance. So let's say, for example, our business, we're a construction business, we have W-2 employees, and we have workers' comp insurance. That's going to be casualty insurance. And you see here different types of liability insurance, as I mentioned. It's going to protect you from tort liabilities from third parties. So let's say you get sued for $100,000. If your liability insurance covers it, it will cover most of that payment to the plaintiff. And we also have a commercial general liability policy. So it basically covers a broad range of risks that a firm can get. So that could be personal injury lawsuits, intellectual property, etc. And then we also have life insurance, which I think is pretty simple. It's typically common for families. But let's say in a corporate setting, we have a life insurance policy for the CEO and founder of a company. they could have a life insurance policy. So they could take a policy on a key employee and provide a payment in the event of the person's death to the company. So let's say Bill Gates dies and he has a $50 million life insurance policy. The life insurance company would make a payout of $50 million to to Microsoft. And then there are different types of life insurance. So we have whole life. So that's going to provide protection for the entire life of the insured party, but it's distinctive because it has a cash surrender value. So a cash surrender value means if you decide to end the policy early and you want to cash out, you can actually get a certain amount of cash for it. The problem is that the cash surrender value is nowhere near as much as the face value of the policy. So let's say you have a $3 million policy, but the cash surrender value is only $50,000. So the cash surrender value is typically a lot less than the whole policy. Also allow you to borrow against your life insurance policy at a low interest rate. So let's say, for example, you want to start a business and you have a life insurance policy. You can actually borrow money against your life insurance policy to provide capital. And then we also have term life insurance. So this is life insurance that will cover you over a specific period. So let's say you have a 10-year life insurance period when you're 80, and let's say you die by the time you're 87. The term life insurance will provide coverage for you because it falls within 10 years. So the premiums compared to whole life insurance is going to be more expensive because you have the option for the cash surrender value. It also covers your entire life. But the term life is typically a lot cheaper because it doesn't have all those options. And that is for insurance. So I want to go over some of the terms here. Can you guys tell me the difference between term life insurance and whole life insurance?
Whole life insurance is for your entire life, and term life is for like a period, like 10 years or something.
Good. Why would someone choose term life insurance over whole life insurance?
It's cheaper.
Good. And what is the payment called to what's the payment called for the policy? What's it called?
Premium.
Good. Perfect. And what is the significance of an effective date? I'll ask one more time. What is the significance of an effective date? Really read what the word is, and you might be able to get it.
It's when your policy begins or becomes effective.
Good. And what about the period in between for when you sign the policy to your effective date? What's the rules regarding that?
I think that's called a binder, right?
Yep, so there will be a binder. That's correct. Good. Can you guys tell me okay, let's take a look. So what is the difference between a incontestability clause and a anti-lapse clause?
Anti-lapse, they like give you 30 days after your premium was due, right? If you forgot to pay.
That's correct. And then what is a incontestability clause?
Is when the insurance can't contest the claim after a period of time.
Yep.
Or
Good job. And what's the typical time period? How many years?
was it 2?
Yep, 2 years. Good job. Okay, perfect. And okay. You got it. And can you guys give me an example of why it's important for a business to have general liability insurance?
If they lost a suit,
They get a lawsuit. Continue.
or if their CEO dies or something.
Yep. Okay, perfect. And can you guys tell me, take a look, what else is there? Effective date, insurance, third party premium, versus term life. Okay, personal insurance. I'm going to go to the other chapters. I want to make sure you guys really get this, because there's a lot in here. 37, I want to get to 32. Okay. Okay, can you guys tell me who should be at a creditors meeting?
It's all of the creditors in Chapter 7.
Good. Who else needs to be there?
The debtor,
Debtor, and there's one more person.
the trustee,
Yes. So let's go back. So the attorney needs to be there, all the creditors, and then the debtor itself. What happens if the debtor doesn't go?
They forfeit or accept whatever.
Scroll back up. Show you guys here. So if they do not attend, if we go back here, right? The court may refuse to grant them bankruptcy. Yeah. Okay, good. Okay, and tell me, what is a can someone give me an example of a discharge? Okay, so let's go back. I think this is one we should go over one more time. So a discharge, it's a written federal court order, meaning that a debtor is immune to a creditor's actions to collect debts. So when a debt is discharged, the debtor is no longer responsible for the debt. Now guys, tell me, what's the one exception to a discharge? There is an exception.
People are answering in the chat.
Can I look? Debt settlement, good. Wait, hold on. Not quite. Debt settlement. Not exactly. There's a specific term. I'm looking for credit card. No. What's the one exception to a discharge?
No, the reformation is the exception to the discharge.
There you
to be
go.
able to-
Reformation agreement.
I meant credit card settlement for the other question.
Okay, got it. Yeah. So, yep, you need a reformation agreement. Now, what needs to happen in order for a reformation agreement to be valid?
It needs to be made before the discharge.
Good. Well, let's take a look. Good. And then the other three, the debtor has to be able to cancel the agreement. The creditor by law does not require the agreement, and it must be filed within the bankruptcy court. Okay. Okay. Okay, and can you guys give me an example of a preferential payment? Let's say someone, no, I want you guys to give me an example of preferential payment.
It's like when you pay majority or all of the debt to one creditor and not the others.
Okay, and then what do you do after you pay the money to the one creditor?
Go into bankruptcy.
Yep. So you pay the money to one creditor, and let's say you can't owe for the other one. So let's say you owe money to a bank for a mortgage, a company for a car loan, and then credit card debt. Let's say you pay the credit card debt off, but you can't afford the mortgage, the car payment. So the person that, let's say you owe the payment to American Express. So American Express Inc. would be the person that receives the preferential payment. Okay. And I'm going to try to get one more done. All right. Let's try to get to chapter 50. Also, a little tip, if you guys want to start businesses, you might want to look at some of these chapters in here regarding entity formation. They're really helpful. We just didn't go over it in this class. It's fine, but real property is also important. Okay. Okay. So in a sublease, guys, who's responsible for the payment of the sublease?
The tenant.
Yep. Good. Okay, perfect. And in order, let's say I own a restaurant and I want to renovate some of the kitchen equipment in my restaurant. Can I just do that because it's my business?
Not if you're renting.
Correct. And can you guys give me some examples of a common area in an apartment building?
Like the gym or the laundry room.
Good. Okay, guys, so that's gonna wrap up for today. Great job. Hold on 1 second. Let me stop the recording.